Of course, should, this is beyond our hands, good or bad, evil or, nice. It is very much applicable. So this is where, we cannot do much except represent. So it should not be applicable to some, but here, we have to apply our mind a little more is that in case of private limited company also, there are people who are shareholders, there may be people who are shareholders who may not be in the controlling, they would have less than 51% shareholding. Now, if the majority, they start entering into transactions which are, not in ordinary course of business or not at arm's length, the terms are bad, then they would suffer. Like, the example given is of PE investors. Now, if these companies tries to enrich their own, group at the cost of the minority shareholders, should that be allowed? So, this is the other side that, whether related party transaction should or should not be allowed. So, there are, both views, this is a common complaint, particularly, startup and all that, see, PE investors generally will try to have shareholders agreement or other structure where they will insist that certain approvals, their approval has to be taken. But other than that, the principle is that minority do need protection. Now the question here is raised is that in case of a group, let's say the private limited company is there, in which there are 3 promoter groups, 50, 25, 15% respectively held by A, B, and C promoter groups, and the remaining 10% is held by a PE investor. The question is, in that particular case, if there is a particular related party transaction, would the other groups, so suppose if the related party transaction is with one of the members of A group, can the shareholders of B group, C group, and obviously PE investors of course will be eligible, but B and C group, they are promoters, they are not related with A group, but they are part of the promoter group. Can they be debarred from voting? Here, the circular of July, which has been given, is like most. Apart from that, even the rules and circulars are very ambiguous. But there they have said that in the context of that particular transaction, who is a related party, he should not be allowed to vote. Other people can vote. Under listing agreement, as we know, no related parties can vote. So if this was a listed company, it could have been created much more difficulty. Here it has been said in the context. Now, what does the meaning context mean? But I think looking at that, a circular has come out, and a circular has come out to give some relief. In that case, see, one of the questions which has been raised that in the context, you mean all the related parties because it has not been specified. I think here it can be said that Group A should not be allowed to vote, Group B, Group C should be allowed to vote, and they and the PE investors should be able to decide. Here I want to still go that how people are giving opinions, how people are acting on opinions, and here again maybe Officer can maybe give his own experiences. There is an actual case, I don't want to name it, it is there if you Google it. There is a transaction, there is a promoter group A, and promoter group A. The transaction was supposed to be entered with the Mr. A. His wife was also holding shares. Then there is of course promoter group B and C and whatever. But in case the transaction was with one Mr. A, his wife was holding shares. Can the wife vote? The opinion given was yes, she can give vote because what is prohibited is that with that particular related party, he should not vote. Everybody else should vote, including his wife. And that opinion has been acted on, and the votes were coincidentally that particular group which was there, and I am talking about a listed company, so I am not even talking of private company. That particular listed company, in that one of the group companies had passed a similar resolution before this circular, and before the amendments to the listing agreement. Before that particular wife was not allowed to vote, they said no, this is a related party. After this, the wife voted at that particular thing, relying on an opinion that only that particular person who is a related party should not vote. So now, as I said, there are various opinions. In this particular case, I will take a view that A as a group should not vote, B, C can vote, P investor of course can vote.
Just one supplement, not supplement, a view on the matter, is that the related party transactions, there's a lot of regulatory ambition, if I would say, in drafting it out, at both the NCA level and the SEBI level. They have written English without understanding what in English would mean finally the practicing word. That's the real problem in there. And therefore, I agree with Jayad's interpretation when you have got 3 groups, 3 groups within promoters ABC group, if A is found to be related, B and C can vote. Let it be challenged in court of law. Until then, I don't think the regulator will understand what they have written and what the principle is exactly. This is I'm sorry to say that, but this is a reality of life because they have written without understanding, without drawing a chart about what it means, where all it will reach. We had a situation, I tell you, slightly out of the way, but I'll do that. Stockbrokers should give information about their associates, and the associates they have got to any extent. Then Goldman Sachs or Merrill Lynch has some broking company in this country, and they had to give me about 6 to 8 pages of names of the companies related to them. And we wanted a shareholding pattern, managing director, KMPs, of all that. 6 to 8 pages of list of names they had to give, and imaginary letter the disclosure they want to make, and what am I going to do with that? If all the information get not related, then we went back and told SEBI saying that you are asking the associate as a too big a word. How do you restrict it? Then they said, okay, let's stop with the broking company in this country. That is, there are a lot of enthusiastic MBAs in the regulator's office. They write this English. So we have to wait for interpretations to come.
Okay, question 24 on page 18. The question raised is essentially that two examples are given that under the old law and under the new law. Under the old law, the useful life of asset number 1 was 20 years. Under the new law, it is 10 years. In this particular case number 1, the asset has already been used for 12 years, and there is a WDV given of 4.50 crores. Now the question is, what do you do in the current year? That's 2014. Now, note 7 of Schedule 2 deals with this particular situation specifically. It says, it says that if you have a situation, and it deals with situation 2 also, that in that particular case, say 20 years was the useful life of the earlier law, 10 years is the useful years now, and now 8, in this particular case, 8 years life has already gone, 2 years life more is there. Now what do you do? In case of 1, the useful life is already over. You already used asset which useful life under the new law was 10 years, now you already used for 12 years. So it means useful life is here. What Schedule 2 says, note number 7b, it says that in that particular case, now see that this particular schedule was amended, recently. Earlier, what Schedule 2, that particular note referred to was that you should adjust, you shall adjust this particular amount as against the opening balance of the reserves and surplus. So this is, the retained earnings, that was the word used. So 4.50 crores shall be adjusted against the balance, the opening balance of accumulated earnings. Now the amended Schedule 2, that particular note says, it may be adjusted. So it means you have got an option to adjust against the accumulated earnings as on 31st March 2014. The question is, suppose you decide, what you don't want to adjust. In that case, what do you do? Can you say that, okay, I'm out of it, can I depreciate over the remaining period? I don't think that is the intention. The intention, and if you read along with ES6, accounting shall not depreciate. Accounting shall not depreciate does not deal specifically with this situation. So finally we have to interpret 7b only. But it does say that, if you have got accumulated depreciation of this particular type, then you should write off during the year. So I think finally the two choices are, you adjust against the opening earnings, so you don't want to take a hit in the current year's accounts. Then you adjust, you may adjust, so you do adjust. Alternatively, if you don't do adjust, you have to adjust in this particular period. I will also rely on, Companies Bill 2014, the wording, just in a related case, they are proposing to amend section 123. And they want to introduce a third proviso, which I will read out. Provided that no company shall declare dividend unless carried over previous losses and depreciation not provided in previous years or years are set off against profit of the company of this particular year. So again, the intention is that don't have any accumulated thing. Write off in this current year. So of course, this is only for declaration of dividend, and the context is also different. But I think taking all these three things together, you cannot say that the words may gives me option not to adjust altogether. You will have to adjust one way or the other. The second point is that you have got 2 years of life, so that again, note number 70 is very clear. What you have to do is now you have to write off this particular remaining amount over the 2 years.
question number 19. It is a very tricky question. What it says is that as on 31st March 2014, Excelsior has paid share capital of 100 crores, security claim to 40 crores, paid account, turnover, etc. There are so many events given here, so many items given here. And please guide as to what could the problems of the new act, advise the company as to steps to be taken immediately. It requires reading of so many items. I think it comes.
Already granting has been over.
I think it's a 38, sorry. I'll take it later on.
Question number 38.
38, sorry. 38 will definitely. We'll go to the question number. It's not 13. Corporate social responsibility. 32. Sorry, question number is 32. For the purpose of requirement of company for CSR, profit means profit before tax or after tax for the last 3 years. Wordings are not clear. On the basis of the question, I closely read this. See explanation to section 135. Explanation to 135. It says it refers to section 198.5. And 198.5 clearly says tax is not to be deducted, and therefore profit means for the purpose of CSR profit before tax. It may be very harsh interpretation, you may not like it, but I think it seems to be the reality because they are referred to 198.5. Because 195 explanation says that. And then ABC Limited are subsidiaries of ABC Limited. A Limited, B Limited and C Limited are subsidiaries of ABC Limited. ABC Limited has formed a group PSR policy for all subsidiaries to follow. Can the holding company carry out the CSR project while the subsidiary companies contribute their share to the same by making the payment to holding company? Read Rule 4.3 of CSR rules. It very clearly says that there could be a group policy and group CSR activity, but each company must be able to place a report on CSR activity in the prescribed format. The format in which they are going to place it, which gives the amount spent, benefit, debt, etc., etc. So therefore, holding company should share transparently all the information with the subsidiary companies, and subsidiary company must be able to place a report before CSR. As such, there is no bar in participation of subsidiary companies or say group companies participating at a group level of the CSR activity. There is no bar at all on this. We will read the Rule 4.3, all this is evident.
We are on page 80 now, question number 25. This is a very interesting question and could have some far-reaching implications. And very well drafted in something. The situation which is given is very, I will remain focused on the situation only because there are so many variants of this particular table. But the good example which is given is that here is a situation where company Y is holding shares in the share capital of the company X. The company X has got two categories of capital. One is equity share capital and one is convertible preference share capital. And then there is a total capital. Company Y is holding 60% of the equity share capital of company X. Company Y is holding 10% of the convertible preference share of company X. Therefore, if you take in the terms of overall capital holding, it is 43.33% of the total capital is held by company Y and company X. The question which is raised is this company X a subsidiary of company Y under the 1956 Act, under the 2013 Act, under the AS 21? And let me deal with 56 Act and AS 21 first. I think the law is very clear, and that is what probably the intention of the queries to highlight is that under the 1956 Act, the requirement is that how much capital do you own of the equity share capital, what is the nominal capital. And in this particular case, it is very clear you are holding more than 50%. Therefore, under the 1956 Act, yes, you are a subsidiary. Under AS 21, similar wording is that if you are holding more than 50% of the equity share capital, you become a subsidiary. AS 21 also is. 2013 Act, intentionally or otherwise, they have taken a different term. They have said that you will count the total capital, that is not the total capital, but the equity share capital plus the convertible preference share capital and see whether that particular company that is buying this particular case, does it hold more than 50% of the total capital of equity and convertible preference shares. Here in this case, on the face of it, the company does not hold. So there are two conditions. One of the conditions is that you should be holding more than 50% of that particular capital. Therefore, that condition does not apply. So you are not a subsidiary under that particular condition. But that I think the answer does not end there. You look at the second condition. The second condition says that if you are controlling the composition of the board of directors of the other company. Now, if you go back to the history of the Act, this particular provision has seen various amendments, control the composition. Because earlier if you go to little back even further, this was heavily misused to create a subsidiary and to get over section 370 and 372 because they used to exempt subsidiaries. So what people used to do was, they used to form a company, hold 10% or so, whatever is permissible under a maximum limit up to 370, 372. Then they used to enter into an agreement with that particular company and ensure that agreement is incorporated in the articles of association of the company. And they used to say that under that agreement and articles, our company, our board will control the composition of your company's board. So immediately, as per that second rule, they become a subsidiary. Once it became the subsidiary, it was exempt under section 370 and 372. So they people went ahead and invested as much as they want without complying the requirements of the rule. And I think at that time, central government's approval. So that they amended. That matter went to courts. Court said yes, this structure is very much valid. Now you could question that whether court should have seen through that the whole thing is a sham. But what you lay down in the articles of association, if that particular board is agreeing to allow another company to control the composition of the board of directors, they pay their to do that. Whatever it is, that was used, abused, misused, whatever. Therefore the law got amended, saying that if this particular you cannot have a subsidy under 372, which is through the control of composition board. In that case, section 370 is not exempt. So that is the history of that particular section. Now what has also happened, the story is always 2 steps ahead of the police. What they started doing was using preference share capital, convertible preference share capital, and therefore they used to have more than they used to hold in such a way that they used to hold more than 50% of the capital there, and at the same time equity share capital was little less, or the other way around. So there are, these provisions were also misused to allow. And see, we have to understand this, that this abuse was there. So what we are facing, 185, 186, 188 and all that, we are talking about harshness, but there is a background to it. There has been so much abuse. So if we don't, look at that and say that, we are facing harshness, then, Sahara and so many other things we should discuss in Sahara and all that, they have heavily misused the concept of deposit, convertible debentures and so on. Whatever it is, so today the situation is, that is the history. But the words control the composition of board of directors. If I am holding more than 50%, in this particular case the table says I am holding more than 60%. Do I control the composition of the directors of X? The answer is according to me yes. That once I hold more than 50% of the equity share capital, I control the composition of that, and therefore it is a subsidiary. And I will cite 2 case laws for this, which deal specifically with this particular situation. One is Delhi High Court decision in the case of Oriental Industrial Investment Corporation. It is of 1981, 51 company cases, 487. There is one more decision of the Kerala High Court, Velayudan versus Registrar, 1980, 50 company cases, page 33.
Say again, sir.
Velayudan, 50 company cases, page 33. Velayudan M versus Registrar. I'll read out a couple of sentences from that, from Delhi High Court decision. Control over the composition of the subsidiary's board is almost invariably derived from the voting rights derived by the holding company by virtue of shares in the subsidiary held by its nominees, but it could also arise from the subsidiary's memorandum of argument. So what it said is, if you control more than 50% of the capital, then you are controlling the composition. If you are not holding, then you would go to the articles. In this particular case, you are already holding more than 50%. Therefore, you are controlling the composition. So under the second condition, you become a subsidiary. Therefore, finally, my answer is that in all the 3 situations, that X is a subsidiary of company Y. Coming to, I think section 26 is already been dealt with by Anup Shah. He has put a whole period of question is that what are the advantages of LLP, whether it is permitted, not permitted, what are the advantages, what are the disadvantages of firm versus LLP. There's been a whole paper and such that we need not go into spend time in that.
This is a very interesting question, scientific philosophical question. A listed company is in the process of formulating its CSR policy, making CSR committee, and yet to commence its activities. The company accountant wishes to know whether in quarterly financial results proportionate provision should be made for CSR expenses yet to be incurred by the company. It's a prudential answer. There's no, I'll tell you, we have to understand a concept called as comply or explain. This particular 135 concept has been brought as the comply or explain process. I'll tell you why. Provided if the company fails to spend such amount, the board shall, in its report under clause so and so, specify reasons for not spending the amount. That is, a company may not be able to spend is foreseen by the provision, and says that the directors in their report have to say why they could not spend the money. If you take a view that company may not spend the money in that year for whatever reasons, and they have got an explanation to give to the public at large, including MCA, etc., then it is possible that you may not spend and therefore no provision is required. But it is a fair amount of certainty that is CSR activity has been initiated, some trust has been entrusted, some activity has been initiated, but money is yet to be disbursed. You are very able to clearly foresee it for the purposes of, from the listed company, for the purpose of creating a true and fair view of the accounts, you may want to make a provision. But in consultation with the management, if you are very clear that you are not going to spend this money during this year, since provision is there available for explaining away why you could not spend, you don't have to make a provision. I don't know whether I am communicating to you. It's a question of there's no penalty for not spending. There's no punishment for not spending. There's no other action to be taken in case not spent. What all is required is only to explain to the world that I could not spend this money. So therefore, comply or explain is the consequence of this particular principle. When it's only a question of comply or explain, then is provision required? Strictly speaking, not required. But if there are policies being formulated and schemes are being drawn up, amount is likely to be incurred in any case, if that's what accountant's view is, then as a prudential entity may provide this expenditure. 135, provision, second provision is important to understand. Yeah. No, company fails.